Okay. I'm back. Um, so my hair's coming back in. I had cancer treatments. Um, just starting with a little background in Brett's case. And this is all documented in our transcripts of our hearings, our witnesses, and everything that we've done since uh, 2006 after Brett's failed first appeal. Um, and just as a little timeline, after his first appeal, we filed the post conviction, our post conviction application, and it was granted. We got our application granted. We were allowed to file post conviction. You have to ask Supreme Court if you can. So we filed that, and we had affidavits from witnesses that I found. I did the first investigation, um, and I found some jaw dropping information and witnesses, and it made sense to me that when I got to the end of the transcripts and I was wondering where's the rest of it, where is the defense? What is this? Now I know the witnesses were never interviewed or uh, taken seriously, or even I mean these witnesses were ignored completely. And now I know why the trial seemed like that, because they had corroborating evidence that Brett was innocent, and were willing to testify, but were ignored, completely ignored. And during the trial, they were stuck in some, as Madge said, a broom closet, you know, with buckets and mops. That's where her and the two witnesses that I found and interviewed for the first time. That's where they were stuck during Brett's trial. Her grandson and his son. So we filed that, and within about 6 weeks, the Mississippi Supreme Court ruled that Brett's post conviction was granted. And they didn't send us back to court or anything. They just granted what we asked for, which was to have his conviction overturned. And as I said before, the judge, that when this lawyer presented this court order to the judge, he refused it and sent us back. And he for a clarification, which isn't the same as a rehearing. It's a clarification, and it should have gone back to the same three that were on the panel, but they switched one of them out, and they put in Randolph, who was the most conservative judge on the court. And when he got on the panel and replaced one of the panel members, the court order changed without explanation at all. They just sent us back to Gardner, Brett's judge, and to ask for a new trial. So we did that, and he was very belligerent towards our lawyer, our female lawyer, kind of treating her like she was just a second-class citizen because she was a woman, first of all, and just, because how dare we? How dare we come back into this man's courtroom and question a conviction? So he had that whole attitude going and was very belligerent, and just it was just a pall over the whole place. And Sylvia, she was the lawyer. She really had to. He would refuse to, answer some of her questions, asking if she could introduce evidence, and it just did. It just was a bad feeling, But we went through the hearing. We presented our witnesses, the two witnesses, with the corroborating, evidence, and he took an entire year to rule. And then he ruled that Brett should not get a new trial. He didn't deserve that. And his witnesses weren't credible. His grandmother and his dad weren't credible, but gave no reasons why they weren't. And he just didn't believe them. And so, you know, it just seemed it didn't make sense that you wouldn't want to present those witnesses to a jury, so Brett could have a jury trial with his witnesses, not a judge deciding. So, because, witness credibility is the job of a jury, and that's legal precedent. That's just that's a known legal concept, principle, that juries decide witness credibility. But he denied Brett that. So that's why I say to this day, Brett's never had due process, because he's never had his witnesses before a jury where a jury decided and their credibility. So we were denied that, and we appealed, obviously. We feel like that appellate court just protected Gardner, so he wouldn't have overturned, he wouldn't be overturned. And, I have found out over the years, they do protect, the lawyers and the judges protect each other. But it just, the decision just was not well written or well thought out or answered any of the questions in our appeal. It was just not good at all. So then we were going to file habeas corpus with the Mississippi Supreme Court. But during that time, Miller came down, which was a case where the Supreme Court decided that mandatory juvenile life without parole was unconstitutional. It was an Eighth Amendment cruel and unusual punishment decision. And so that was a game changer. Obviously, Brett was 15 years old. He had mandatory life without parole. He didn't have, that was an automatic sentence. So, at that point, we were going to appeal the conviction, which we had been, all along. But with Miller coming down, the lawyer wanted to concentrate on resentencing under Miller to get Brett a chance at parole. So I guess it was and they also wanted to win this. It was just part of a lawyer thing where, we need to win this. We need to get our names on this Miller stuff in Mississippi. All these juveniles locked up with life for life. We need to overturn all that and get new sentences, and we want our name on it. And so they kind of switched all the momentum to this Miller stuff. I did convince the lawyer. We had a new lawyer at this point. Brett didn't want this woman anymore. He felt like she kind of dropped the ball. So I hired a new guy, Mr. Freeland, and he just wanted to, I talked him into preserving some of our conviction issues. Thank God I did. Especially the ineffective counsel claim. And there was two others, a flight instruction, I can't remember what else, that he preserved, luckily. And then they just went after the juvenile mandatory life, which we ended up winning that. But the court did not want to look at any of the other stuff. They only wanted to look at the Miller stuff. So we never really had any review of the Court of Appeals decision that Gardner denied Brett that new trial. They didn't want to review that. They said they were just going to review the sentencing part under Miller, because that was the popular issue of the day. So that's what they chose, and overturned Mississippi's law on mandatory sentencing on that. So Brett got to go back and get resentenced. And then that set precedent for all the rest of the cases that all had to be, resentenced. So that started a whole nother aspect of the case, preparing for that hearing. And so then, we did that. And regardless of Brett's hearing, which was very good evidence for him that he should get parole eligibility. He was not incorrigible. And, it was a good hearing for him. And, but the Gardner decided, nope, he was going to give him life without parole again, regardless of what Miller said. And he didn't find that he was incorrigible. He didn't say anything. He just said, he looked at the Miller, factors. They call them the Miller factors. And in his head, not on paper, in his head, he went over the Miller factors, and Brett was not eligible for parole, he said. Too much of a bad guy. And the worst of the worst, apparently. And so that's what we sentenced him to. And we appealed that all the way to the Supreme Court. And the question asked was whether or not you need to make a finding of incorrigibility, as Miller and Montgomery, the case that came after Miller, said that you should have to do. It was required. Well, with the new Trump court, we lost our Miller justices. Kennedy retired. RGB died. Who else did we lose? I don't know. So that they were on the Miller side of things, and Roberts. And once the court was stacked with Trump justices, we didn't have a chance in hell. And they did gut Miller. They gutted it. They made it so that with our case, they made sure that juvenile life without parole was back. There was no presumption of being a child, like Miller made that the presumption that you were a child and these were the factors, and the state had to prove otherwise. But they reversed all that and made it the child's burden to prove he was a child, thought like a child and all that. And also reinstated that. And what was the other thing? No need for a judge to show his work and make a finding of any kind. No, on paper. No record. You don't need to make a record of that. You can just kind of decide in your head and then not put anything down on paper or make a finding that a juvenile is incorrigible, the worst of the worst. That wasn't necessary, this court said. Judge can do what he wants because a judge is a judge. Do what he wants. I mean, the assumption was the judge thought it out in his head. He made the right choice. So that's a presumption. So that's kind of how they left it. And so that's kind of the whole history. There's a lot more little anecdotes of each one of these proceedings that I just would be so fucking fun to talk about. Just to see the kind of corruption and just to see the bad luck that Brett's had. Just the absolute bad luck over and over and over again. Maybe on another video I'll do that, because this is just kind of a little history of all the appeals. And then Brett's lawyer and then he filed in federal court. And he was able to challenge his conviction in federal court as well as the sentencing, because his lawyer won a case, the Greenwood case, where with these juveniles that have been resentenced, that restarts the clock for their conviction too, because the sentence and the conviction are come together. They're together. So if you resentence someone, that conviction now is attached to that new date of that resentencing. The punishment part, the judgment part. The sentence is the judgment, so the conviction goes with that. So that pushed Brett's conviction all the way up to when he was resentenced, which meant he wasn't time barred or procedurally barred to bring that conviction back up again and fight it, challenge it. So that's what we did in his federal appeals without a lawyer, because his lawyer refused to do it. He worked for the MacArthur Justice Center and said they weren't allowed to do anything like that. They can only, their only job was Miller. That's it. They didn't have any authority to fight convictions. So Brett had to do that by himself, pro se, which he did. And he did a great job. And all of that is on the PACER docket, if anybody's interested in reading Brett's appeal that he did himself and I thought was exceptional. And when I read it and explain, it was just very good. He didn't even have a magistrate. We think something goofy was happening there too. Most cases are assigned to a magistrate judge, and then the magistrate judge makes the decision, and then the federal judge on the court either agrees with the magistrate or doesn't. Brett didn't get a magistrate. We to this day don't know why. It went directly to a retired justice who turns out was from where Gardner's from, same area. The son is working in the court system over there, his son. So we just thought, oh, wait a minute. This isn't comfortable at all. This judge we ended up with, a retired justice on a murder case for a child. It just didn't seem, Well, he denied everything, and then he wouldn't give us a certificate of appealability to go to the Fifth Circuit. He said no. So you can't, to file the habeas. It's impossible. If you don't get a certificate of appealability, you have to ask the Fifth Circuit for one, and chances of that ever happening are 0 and none, that door would open. So we didn't get into federal court. So that was basically the end of the appeals. I think they ended in 2023, maybe. We finished up in federal court. So that's everything that I know about right now.